like watching someone pass airport security with a perfect passport, only to find out years later the entry stamp never matched the flight log. So here's the question. If the system approved it, stamped it, and filed it, does that make it true or just unchallenged? Because at 9:47 a.m. on a Monday, inside a sealed federal chamber, Pam Bondi walked in with something that didn't just question a story, it challenged the record itself. And when the person challenging the record is the same person who used to defend it, you're no longer looking at a disagreement. You're looking at a structural problem. This is not a normal hearing, this is not a media leak, and this is definitely not a political talking point dressed up as a legal moment. This is a federal proceeding, logged, time-stamped, and extended by a judge who clearly understood that what was being said in that room could not be handled in routine time. Because when Pam Bondi spoke, she didn't speculate, she didn't hedge, and she didn't soften the language for optics. She told the judge directly, "The records submitted do not reflect the actual timeline. I have documentation that establishes a different sequence of events, not a theory, documentation." And that statement lands differently when it's directed at the official history surrounding Melania Trump, a history that, until this moment, had been consistently defended across multiple legal challenges and multiple administrations. Now pause there, because this is where most people miss what actually matters. It's not just what was said in that chamber, it's what had to exist before she walked into it. Because people don't walk into a sealed federal session and improvise contradictions to official records. They walk in with filings, timestamps, cross-referenced databases, and a chain of documentation that can survive judicial scrutiny. And according to the filings tied to this session, April 14th, April 17th, April 18th, there is a pattern of inconsistencies between submitted immigration documents and independently verified federal entry logs. A pattern where timelines that appear clean on paper start to fracture when cross-checked against external records. And most importantly, a pattern that includes a phrase that lawyers don't use casually: corrective documentation. Let's slow that down, because this is where the logic tightens. Corrective documentation means something existed, it didn't align, and it had to be adjusted, submitted, and accepted into the official record. Which is fine, until someone with access to the original structure steps forward and says the sequence itself was never accurate to begin with. Now here's where it gets uncomfortable. Because if a regular person submitted documents with inconsistencies across timelines, mismatched entry records, and later corrective filings, that person wouldn't be sitting in a sealed chamber with a judge extending the session to understand it better. They would be facing immediate scrutiny, possibly rejection, and in some cases legal exposure. But this isn't a regular person. This involves Donald Trump's inner legal orbit, a former attorney general, and documentation that has already been processed through the highest levels of federal systems. And that's exactly why this moment matters more than any headline will admit. Because this isn't about whether one document is right or wrong. This is about whether the system that accepted those documents applies the same standard when the person under review is connected to power. And as this chamber session unfolds, with Exhibit F still sealed and a deadline set for April 23rd, one thing is already clear. The story didn't break in the media. It broke in the record. And here's where the narrative starts to tighten. Not in headlines, not in commentary, but in the documents themselves. The ones stamped, filed, and time-logged before anyone ever heard the phrase Exhibit F. Because if you go back just a few days before that Monday morning, the sequence doesn't look dramatic at first glance. April 14th, an official records request, processed through FOIA channels, surfaces a discrepancy that shouldn't exist if the timeline were clean. A gap between declared entry dates and independently verified federal database logs. Not speculation, not interpretation, just a mismatch sitting in two systems that are supposed to agree. April 17th, 3 days later, a formal motion is filed in federal court. Page 23 referencing substantial inconsistencies. Page 31 going further, pointing to a structural conflict between submitted documentation and mid-1990s immigration records, the kind of language attorneys don't escalate to unless they're prepared to defend it line by line under judicial review. Then, April 18th, a legal analyst brief begins circulating, not public-facing, but within constitutional law circles, identifying 3 specific problem zones: timeline misalignment, identity documentation irregularities, and prior communications suggesting those issues were known and addressed internally years ago. Now stack those 3 together, not as isolated events, but as a sequence, and the pressure builds. Because one document raising a question can be dismissed, two can be debated, but three, across different channels, different dates, and different legal frameworks, start to form something harder to ignore, a pattern. And patterns are where legal risk begins to crystallize. But here's the part that shifts this from technical discrepancy to something much more serious. The 2019 communication. Buried in the filings, referenced but partially redacted, it contains that phrase again. Corrective documentation being processed, not discussed publicly at the time, not litigated, just quietly handled within a legal communication involving parties connected to the executive orbit. Think about what that implies. If documentation required correction in 2019, and that correction aligned the official record going forward, then the version of the timeline accepted by federal systems after that point is not necessarily the original sequence, it's the adjusted one. And that's not inherently illegal, but it becomes legally explosive the moment someone demonstrates that the adjustment concealed a discrepancy that would not have survived aggressive scrutiny. That's exactly what Pam Bondi is now implying in that sealed chamber. Not that documents were filed incorrectly, but that the sequence those documents represent, the timeline itself, does not match the underlying record. Now follow the logic carefully because this is where the internal contradiction sharpens. On one side, the official account has been consistent for years, defended successfully, verified across multiple reviews, presented as settled fact. On the other side, you now have a chain of filings, April 14th, April 17th, April 18th, pointing to inconsistencies that cannot coexist with that settled version of events. Both cannot be true at the same time. And when two incompatible timelines exist within the same federal record system, the question is no longer which one sounds more credible. The question becomes, which one survives evidence scrutiny under oath? Because courts don't resolve narratives. They resolve records. And the moment those records begin to conflict internally, everything shifts from interpretation to verification. That's why the judge didn't treat this as routine, that's why the session extended, and that's why Exhibit F, still sealed, still unknown, has already become the gravitational center of this entire proceeding. Because whatever is inside that document doesn't just support an argument. It either stabilizes the official timeline or it breaks it. And this is the point where the room changes. Not emotionally, not politically, but procedurally, the kind of shift you only see when a legal system realizes it might be looking at two versions of reality inside the same record. Because once Pam Bondi places that statement on the record, once she introduces Exhibit F, the burden quietly flips, not in theory, but in practice. Because now it's no longer about proving a new claim, it's about defending an existing one that was assumed to be settled. And that's where the pressure starts to build in layers. Not noise, not speculation, but receipts, timestamps, filings, cross-referenced entries that don't align the way they're supposed to. Take the official timeline surrounding Melania Trump, a timeline that has been presented consistently across years, across administrations, across legal challenges, always resolved, always verified, always closed. Now place that next to what the April filings suggest. A mismatch between submitted documentation and independently verified federal logs, not once, but repeatedly, across separate filings, separate sources, separate dates. If those mismatches are real, then the verified timeline wasn't verified in the way people think it was. It was accepted. And those two things are not the same. Because acceptance means the system processed it without challenge. Verification means the system stress-tested it against every conflicting record it had access to. And what this proceeding is exposing is the possibility that those stress tests never fully happened. Now add the 2019 communication back into the frame, the one referencing corrective documentation, the one involving a party still operating within the executive orbit, the one whose identity remains redacted across every public version of the filing. Ask yourself a simple question. Why redact that name now, in a document that is already part of an active federal proceeding? Redactions are not random. They are deliberate. They protect something, either a person, a process, or exposure that hasn't been fully addressed yet. And if that communication shows that inconsistencies were identified, acknowledged, and then corrected without ever triggering a full public challenge, then the issue isn't the correction itself. The issue is what the correction replaced. Because if the original sequence of events would not have survived aggressive legal scrutiny, as one of the filings explicitly suggests, then the corrected version isn't just an update. It's a shield. Now bring that back to the chamber. When Bondi tells the judge the timeline does not reflect the actual sequence of events, she's not arguing about interpretation. She's pointing to a divergence between what was submitted and what actually happened. That's not a political claim. That's a factual contradiction. And in a federal court, contradictions don't coexist peacefully. They get resolved one way or another. This is where the other side's argument starts to lose structural strength. Yes, they say the transcript is partial. Yes, they argue context is missing. Yes, they frame this as politically motivated. But none of those arguments address the core issue. They don't explain the mismatch. They don't explain the 47-minute extension. They don't explain why additional attorneys were summoned. And most critically, they don't explain Exhibit F. Silence in a courtroom isn't neutral. Silence is strategic. And when the response avoids the central evidence while focusing on motive, it tells you exactly where the vulnerability is. Because if Exhibit F were irrelevant, it would be dismissed. If it were weak, it would be challenged immediately. But it's sealed. It's logged as material, and it triggered procedural escalation the moment it was introduced. That's not how courts treat noise. That's how courts treat risk. And now that risk isn't hypothetical anymore. It's scheduled. And this is where the story stops being about a chamber, a document, or even a name, and starts becoming something far less comfortable. Because once a federal record is placed under internal contradiction, the question is no longer what happened. The question becomes, what do we trust when the system says it's verified? Because think about it in plain terms. No legal jargon, no courtroom framing. If an ordinary citizen submitted documents that didn't align with federal entry logs, then later submitted corrective documentation to fix that mismatch, and years later someone inside the system surfaced the original inconsistency, that case wouldn't be described as routine. It would be described as exposure. So why does this feel different here? Because of proximity to power. Because the name tied to the record is Melania Trump. Because the legal orbit surrounding it connects back to Donald Trump. And because the person now challenging that record is Pam Bondi, someone who didn't just observe the system, she operated it at the highest level. That's the moral fracture line. On one side, a system that tells the public its records are verified, stable, and final. On the other side, a sequence of filings, communications, and now a sealed exhibit suggesting those records may have been adjusted in ways that were never fully tested in open scrutiny. And if that gap exists for someone this close to power, the obvious question is unavoidable. What happens to everyone else who doesn't have that level of access, protection, or correction? Because this isn't about partisan advantage, this isn't about who wins a headline cycle. This is about whether the same rules apply when the stakes change and the names get bigger. And the system is already reacting, not rhetorically, but procedurally. 3 watchdog organizations filing inquiries within hours. Federal judges requesting full exhibit access. Immigration attorneys across the country reviewing chamber logs like they're reading a stress test of the entire documentation process. That doesn't happen over nothing. That happens when professionals recognize a signal before the public does. And then there's the response, the carefully worded statement that calls this routine, that avoids Exhibit F, that sidesteps the 47-minute extension, that leans on the idea that a complete record will resolve everything later. Later. Always later. But here's the problem with that framing. Courts don't extend proceedings for optics, judges don't summon additional counsel for routine filings, and material exhibits don't appear in chamber logs by accident. Those are not political reactions. Those are institutional reactions to something that carries weight inside the system itself. So now we wait. April 23rd, when Exhibit F may enter the partial public record, and May 6th, when both sides will stand in the same chamber with the same judge and the same set of documents that can no longer be separated into narrative and counter-narrative. Because at that point, one of two things happens. Either the official timeline stabilizes under scrutiny, or it fractures under its own contradictions. And if it fractures, the damage doesn't stay confined to one case, one name, or one administration. It moves outward into the one thing systems depend on more than anything else: trust. Trust that when a record is accepted, it was tested. Trust that when a timeline is verified, it was accurate. Trust that the rules don't bend based on proximity to power. So here's the question that actually matters, not just for this case, but for anyone watching this unfold. If the system only corrects itself when someone from the inside decides to challenge it, was it ever truly stable to begin with? If you want the full breakdown when Exhibit F drops, Not the headlines, but the actual filings, the actual language, the actual record. Like this video. Comment what you think is inside that document. Share this with someone who still believes official records never get revisited. And subscribe, because the next update isn't coming from speculation. It's coming from the file.